It was a topsy-turvy week in state government after the Michigan Supreme Court ruled the governor couldn't extend Michigan's state of emergency without legislative approval, and that many of her executive orders issued over the last several months didn't have standing. What followed was a flurry of executive orders by the Department of Health and Human Services to reinstate some of those orders, namely a mask mandate and social distancing requirements.
Right now, under the Public Health Code, there is a section that you'll see referenced frequently that actually allows the director to respond to an epidemic. The language, it's only 2 sentences. The authority is quite broad and it seems to be lacking in limitations. So yes, right now we do have to look to those orders and they do carry penalties for violation. Important to note is that right now those only last until October 30th, which my understanding is that will give the agencies time to find other authority, but hopefully that'll be used to also allow time for the legislature and the governor to work out something else. It's important for those 2 branches of government, the executive and the legislative, to get together and work out how best to move forward and to respond to COVID-19.
The governor also asked for clarification on when the ruling takes effect, now or in a couple of weeks. Meanwhile, the legislature is also meeting this week and next week to formalize some of those orders, like unemployment benefits and allowing local governments to meet electronically. For farm employers and farm workers facing a mandated testing requirement from the MDHHS, for now, that order still stands.
The director's order did cite to some executive orders of Governor Whitmer at the time. That order was issued under the section of the Public Health Code that allows the director to respond in an epidemic. So right now, we don't believe that there's any change to that order. However, I do suspect that in the coming days that we can see a legal challenge to those orders.